We can start the proceedings. Audible now.
The council seeks permission to begin. Much obliged, your lordships. Warm greetings to your lordships. If it may please this honorable court, I am counsel number 1, appearing on behalf of the petitioner in the instant case before this honorable court. The council seeks to deal with issues number 1 and 2, and my co-counsel will be dealing with issues number 3. Would your lordships appreciate a brief perusal of the facts of the case in hand?
Please.
Indeed, your lordships. Your lordships, there are 3 petitions clubbed together before this honorable court, all of them challenging the constitutional validity of the various personal laws of Indus. The first petition consisting of 3 petitioners: 1, Durga, which is a voluntary NGO involved in the elimination of gender discrimination; 2, the petition made by Sharada Devi, who is a widowed mother of the deceased Hind female, challenging the constitutional validity of Section 15, whereby there is no parent entitlement in the presence of husband and his heirs; and 3, Fatima Bibi, an unmarried Muslim girl who is entitled to only one half of the property inherited by her brothers, challenges the same on the ground of it being discriminatory and violative of the fundamental rights. Your lordships, the second petition is filed by Mr. Hemant, the father of a deceased son, challenging the constitutional validity of Section 8, whereby the mother is a preferential heir and the father only falls under Class 2. Your lordships, the last petition is filed by Vairamani's mother, challenging the dismissal of a civil suit on the ground of non-maintainability, as the Hind customs do not apply to transgenders. If your lordships are satisfied with the summary of the facts, may the council proceed with the issues? Much obliged, your lordships. The issues of the case in hand include whether the provisions of the Hind Succession Act are in violation of the constitutional provisions. The second issue is whether the practice followed by Muslims based on Shariat, being a law under Article 13, in regard to the inheritance of Muslim women, is violative of Articles 14, 15, and 21 of the Constitution of Indus. The third issue is whether the non-mentioning of provisions in the Hind Succession Act regarding the intestate succession of transgenders is a ground for dismissing the civil suit as not maintainable. With the permission of your lordships, may the council proceed with the first argument of the case in hand? Much obliged, your lordships. The council humbly submits that the provisions of the Hind Succession Act are in violation of the constitution provisions. The council will be examining the constitutional validity of Section 15 of the Hind Succession Act 1956, as well as the constitutional validity of Section 8 of the Hind Succession Act. Your lordships, it's humbly submitted that Section 15 of the Hind Succession Act is not constitutionally valid due to the presence of unreasonable distinction that is made with regard to Section 8 and Section 15. Your lordships, as regards Section 8, both the mother and the father come under the enumerated heirs, with the mother being a preferential heir. Therefore, in case of a male child, there is at least a parent entitlement. However, in case of females, in the presence of husband and his heirs, there is no parental entitlement. Therefore, it can be rightfully established that such a distinction regarding the rules of succession between a Hind female and male is discriminatory, as it promotes the irrational belief that once a female is married, she cuts off her relations with the maternal home, and therefore her property shall be preserved in the marital family and devolve upon the heirs of a male. Therefore, on her death, the husband and his relations are prioritized over the female's paternal relations. This further hampers the rendering of justice to the female's parents. Your lordships has also submitted that there is no rational nexus which has been established between the basis of classification and the object of the Act. Your lordships, the object of the Act clearly mentions that it is an act to amend and codify the law relating to the intestate succession among Hinds. Although, on a plain reading of the sections, it can be noticed that there are different rules of succession given in case of a male and female, and the notable point to be mentioned is how there is a baseless classification regarding the rules of succession of Hind male and female dying intestate. In case of female succession rules, it seems unfavorable and unreasonable.
Now, counsel, I
Yes,
have a question. Now we are speaking about succession, the difference in succession rights regarding males and females. Is there anything which prevents a person from writing his will, his or her will, the way she or he intends to give his or properties after death?
No, Your Lordship.
So why can't each
Yes.
person write their will? Let them write their will. Now,
Indeed, Your Lordship.
now we are speaking about a situation in which every person, unless he or she writes the will, is happy that let the property, my property, devolve upon the way the Succession Act lays down the rules.
Indeed,
If
Your
not,
Lordship.
if he or she is particular that her property should be devolved in another manner, they can write a will. So doesn't that mean that the person who holds the property wants the property to be devolved upon the successors as per the Succession Act itself?
Your Lordship, the Council would like to bring the court's notice to the 7th paragraph of the Moot proposition, whereby it says that Dr. Rukmini met with a car accident and passed away on the spot at the age of 30. This was indeed an unfortunate death, whereby Dr. Rukmini wouldn't have expected herself to have.
Hello.
Yes, Your Lordship.
See, Council, the point is we cannot decide a constitutionality of a provision based only on the particular facts of one particular case. We have to consider that as a whole, considering the majority of the people to whom the act or the discrimination applies. When you apply
Indeed, Your
that
Lordship.
principle, can you say that, see, the point is, see, any male or female, as the case may be, has an absolute right to dispose her property or his property however he wants to do it. And you have to assume or presume that a person who chooses not to do that wants the matter to go as per the laws of succession. Now, can you say that a person who has spec successionis has entitled right to succeed?
Your Lordship, with regard to writing a will, this can be done at any age. Yes, Your Lordship.
Council, before moving on to answering the question posted by my learned brother judge, I have a concern. This court also do have a strong concern regarding the maintainability of this petition, because whether Article 32 petition is convenient enough for you to file a case regarding a matter at hand, that is a serious concern. Whether the jurisdiction provided by under Article 32 is able-bodied to address your issue is also a matter of concern. So both the questions raised by my learned brother judges do have that shade as well. So kindly answer your question, answer the question with respect to that aspect as well. Because there is a popular concept called alternative remedy. So whether alternative remedy is involved or not. So you have to answer that as well.
Indeed, Your Lordship. Your Lordship, as regarding writing a will, there is no prescribed age at which a person may write. Therefore, in this case, it can only be assumed that Dr. Rukmini wouldn't have expected the death, and so she did not write the will at such a young age. And Your Lordship, as regard the maintainability, we did not take that as a main issue, because we were hoping that the arguments would basically show that since there is a violation of the constitutional rights, it shall be maintainable before this honorable court.
Why this court is concerned about the question of maintainability is that since you're talking about the case of your petitioner, that is Sharada Devi, an unfortunate event happened in her life. She lost her daughter, and there is a dispute regarding the property. There is not even a dispute. There is a chance of having a dispute turned up. So what she did was filing an Article 32 petition before this court. So what is the logic? What is the patent logic behind this? Rather than she could have approached the appropriate court which is concerned, rather than exhausting Article 32. So that is the serious concern that this court is having. So that is something that should be decided in the first place. Otherwise, this petition can be disposed of in the limine.
Indeed, Your Lordship. The council agrees to the same. However, the whole argument is based on how the provisions are violative of the fundamental rights, and that is why Sharada Devi has approached this Honorable Supreme Court, hoping that the judgment would be in her favor.
Could you please enlighten us how these provisions are violated? You're
Indeed,
claiming
Your
that
Lordship.
Section 15 is violated. How it is violated?
Indeed, Your Lordship.
What is the
As
action
regards
involved?
Indeed, Your Lordship. Your Lordship, like the Council already mentioned that there has been no rational nexus that has been established between the classification and object of the Act. Furthermore, this is just something that is an unreasonable distinction, and for the same reason, it is in violation of Article 15, Clause 1 of the Constitution of Indus. Your Lordship, this baseless discrimination is violative of Article 15, Clause 1 of the Constitution, which provides that the state shall not discriminate against the citizens on ground only of religion, race, caste, sex, place of birth, or any of them. However, Your Lordships, in the
See,
instant case,
one doubt. See, what
Yes.
is the logic of Article 15? Why is the exception carved out in Article 15 as against Article 14?
Your Lordship, in 15, it says that it will be violative of the fundamental rights where it is only on the ground of religion, race, caste, sex, place of birth. So if there is any other reason along which where there is a reasonable classification made, then that is justified.
No, no,
However, here it is...
no, I
Yes,
am
yes.
asking you, why was an article as Article 15 introduced into the Constitution as an exception to Article 14? What was the purpose of the Constitution in making Article 15 according to you?
Your Lordship, as per the twin test, that is, if a legislation can prove that it was made where there is a rational nexus or an intelligible differentia, if that can be proven, then
No. You have not got my question. See, what does Article 15 say?
no discrimination on the basis of only on the ground of religion, race, caste, sex, or place of birth, or any of them, Your Lordship.
What about the preferential discrimination in favor of females?
Yes, Your Lordship, when it comes to 15 Clause 3, it also makes a positive discrimination, which says that special provisions can be made with regard to women and children for the upliftment.
And what is the logic in that?
Your Lordship, that is on the basis of principles of equity to bring the weaker sections to the level of the sections which are good to do.
So you admit that females are a weaker section?
Your Lordship, most of the legislations as well as the Constitution
Okay.
itself provides Article 15 Clause
So
3.
going along those lines, don't you think females ought to have better protection under the laws of succession as well?
Indeed, Your Lordship, indeed.
Then how can you say that the Hindu Succession Act is violative because it makes better protection for female legatees of the deceased rather as against the males?
Your Lordship, the concern here is mainly with regard to parent entitlement. That is, if we take the case of females, their parents are not being acknowledged as the male parents are. Therefore, the provisions are in no way in support of a female's rights.
When you are challenging the Succession Act, what aspect of the Succession Act are you challenging? The discriminatory part. What is the discriminatory part that you are mentioning? Can you just enumerate?
Indeed, Your Lordship. The discriminatory part is how, in case of males, there's at least a parent entitlement because the mother falls under Class 1 heirs. But when it comes to females, it's almost like her maternal family is not considered in the presence of husband and their heirs. So if the husband and the heirs are alive, the property would only devolve upon them. And the female's families are not even considered. And that renders injustice to the female's family, Your Lordship.
Okay.
Much obliged, Your Lordship. May I proceed with the arguments? Indeed, Your Lordship. Your Lordship, furthermore, Mullah in his book Principles of Hindu Law also states that Section 15 of the Hindu Succession Act is premised on the understanding that property should not devolve upon an individual to whom justice demands it should not pass. Your Lordship, in the instant case, the mother, who is a poor widow, worked day and night as a housemaid to earn some money to provide for her daughter's education. Furthermore, on the perusal of facts, it can be observed that the deceased and the husband's marriage was completely broken down owing to Rajiv's act of deserting her without obtaining divorce.
See, counsel,
As per the laws,
as I told you earlier, the facts of the case do not consider or are not to be considered to test the constitutionality of a provision. It has to be discriminatory vis-a-vis all the persons, not just the person in the particular circumstances that are as your client. Okay, so let's
Indeed,
not
Your
argue on
Lordship.
that basis.
Indeed, Your Lordship. The council would also like to take support of the judgment made, of the observation made in Mamta Dinesh Vakil versus Bansi S. Wadhwa, whereby the court held that the rules relating to the succession of Hindu females for the items specified in section 15 are wholly distinct and different from those relating to the succession of Hindu males in class 1 of the schedule. The codification of the old Hindu law has not kept pace with the constitutional mandate of gender equality and in removing gender disparity completely. It is also brought to the court's notice that in an ongoing proceeding before this honorable court, in the case Kamal Anand Kopkar versus Union of India and another, it is also challenging the constitutional validity of Section 15 of the Hind Succession Act, and this court has also issued a petition noting that this distinction has raised an important question on gender equality. With the permission of your lordships, may the council now proceed with the second argument.
You may proceed, but keep in mind that you have only 5 minutes.
Indeed, your lordship, much obliged. The council humbly submits that the practice followed by Muslims based on Shariat, being a law under Article 13 in regard to inheritance of Muslim women, is violative of Articles 14, 15, and 21 of the Constitution of Indus. Your lordships, the intestate succession laws of the Muslim community in Indus are primarily based on the Mohammedan law, which comprises of the recitals of Holy Quran, the long-standing practice of the founder of the religion, which are given recognition in the face of law through the legislative enactment of the Muslim Personal Law Shariat Application Act 1937. The council would also like to bring the court's notice into the interpretation.
Shariat law, common for Muslims worldwide.
Your lordship, I'm sorry, you're not audible, your lordship.
The Shariat law, common for Muslims worldwide. Are Muslims in Dubai or UAE or any other part of the world governed by the Shariat law?
Your lordship, the council believes that this is applicable to the Muslims in India. When it comes to Muslims, there's no law.
Are you aware that there are two sets of believers in Islam? Shia
Yes,
and
your
Sunni?
lordship. Yes,
And
indeed,
that
your
there
lordship.
Personal law is different in various aspects regarding the two.
Indeed, your lordship. The council is
Then
aware
how
of
can
the
you
same.
say that how can only this law is applicable to all Muslims in India?
Your lordship, the Muslim laws of succession are basically based on the interpretation of Quran, that is under chapter 4 verse 11, which says Allah commands you regarding your children, the share of male will be twice that of the female. And the same can be seen with regard to Hanafi law of succession as well, whereby the son gets double of what the daughter gets. So from the above verse gains the present position of how the property is inherited by a female child. From a broad reading, it can be seen that there's a bias that is given to the male child, as the verse commands for a person's property to be divided in such a manner that the daughter only receives one half of what the male child gets. And furthermore, it adds in cases where a person is not succeeded by any male heir, the female child is entitled to only one half of the property of the deceased. Your lordship, this actually
there is some logic to that proposition. See, there is a concept called meher in Muslim personal law. That is a female at the time of wedding is supposed to be granted to be given by her parents, which is supposed to provide for the future welfare of the female at her husband's house. Now, when you consider the concept of meher vis-a-vis the concept of equality of a female successor as well as a male successor, there would be some sort of an equation, because now if you seek that there should be equality in that, then the next step would be saying that males should also be entitled to meher, or that the concept of meher should be done away with, so that there is absolute equality. What do you say about that?
Indeed, your lordship, but that comes under marriage. If we look into the rules of succession alone, then in case of succession, equality must be brought about, your lordship.
It all comes to equal distribution of wealth. It all comes down to property, whether it's succession or marriage. Now, please could you answer the earlier question regarding Shariat law? Is it applicable only to India, the Indian Muslims, or the Muslims in this nation, or worldwide? So what would be the effect if we strike down that a portion of the law as not applicable to Indian Muslims, but at the same time it will be applicable to Muslims all over the other parts of the world?
Your Lordship, the Council pleads ignorance with regard to the applicability of the Act.
You can conclude the arguments. Your time is out. You can take 2 minutes. You can conclude the arguments.
Much obliged, Your Lordships. The Council also humbly submits that the personal laws contain discriminatory provisions and the state as such does not violate any fundamental rights. However, allowing the continuance of the practice of such discriminatory provisions also leads to the violation of the fundamental rights. The Lordship has further submitted that as regards Article 21, right to livelihood is also affected, whereby the female child does not get an equal share as that of the son, and therefore that also in turn limits her source of livelihood, as the right to life also enshrines the right to livelihood as well, thereby limiting her ability to have a proper livelihood. It is further submitted that the whole concept of succession is usually based on the notion that a female child, when she is given a property, she cannot use that property for the welfare of the family. On the other hand, in case of a male child, a significant portion of it is to be utilized for the welfare of the household. Although the Council humbly submits that in today's modern world, a system of close-knit family living under the same roof and all members of the family supporting each other is practically non-existent and is prevalent in the society to only a handful of household names, and only nuclear family systems are in such numbers. Therefore, it is humbly submitted that the discriminatory provisions that are provided under the personal laws result in inequality when it comes to women, and they're violative of the provisions of Article 14, 15, and 21 of the Constitution of India. If the court has no further queries, that concludes my submission, Your Lordships.
Council, I need a little clarity on one aspect. The thing is, like, according to the paragraph 8 of the proposition, it stated that the petitioner, challenged the religious instruction providing double share to brothers as discriminatory and violative of fundamental rights. Right. So, as pointed out by learned brother judge about the source of this Muslim law, the primary source is Quran, right? You're not denying it. And the secondary source is the kind of principles, practices, and all things by the disciplines of the Prophet Muhammad, the primary person, the most important person in the Muslim religion. So here in this Article 32 petition, you are directly challenging the religious instructions. So is it possible to challenge the religious instruction under an Article 32 petition?
Your Lordship, as per Shaira Banu case, it was held that the Shariat Act comes under Article 13, Clause 3, Subclause B.
I'm just quoting exactly what is written in the proposition. What is you challenged religious instructions. So is it possible religious instructions can be challenged under the jurisdiction provided in Article 32?
Your Lordship, various schools have actually set up the rules.
So okay, you are the petitioner. Who will be on the other side as a party when you challenge the religious instructions?
It is the state, Your Lordship.
What is the role of the state when it comes to religious instructions are concerned?
Your Lordship, when it comes to the Shariat Act, since it's a legislative enactment, it would be the state.
Shariat Act is not a religious instruction.
Your Lordship, it is not a religious instruction, but here we are basically challenging the Shariat Act, which is in furtherance of the statement made in Quran.
See, the primary we are doing right now, because you concluded your arguments, but we are still doubtful about the maintainability of this petition at this later stage, because you challenge the religious instruction, the scope of Article 32, under the scope of Article 32. Is it possible?
Your Lordship, since the state allows the continuance of the practicing of discriminatory provisions as per, not provisions, but the religious instructions, it still is violative of the fundamental rights. And we have brought this matter before this Honorable Court, hoping that the court would intervene and remove such discrimination.
I would comment that you are trying your luck here. Yeah. Thank you, counsel. You can move on to the second speaker can start.
Much obliged, Your Lordships.
May it please this honorable court, I am counsel to appearing on behalf of the petitioner in the present case. Your Lordship, the counsel will be dealing with the third issue of the case. Your Lordship, the counsel seeks permission to present the third issue.
You may proceed.
Your Lordship, the third issue is whether non-mentioning of provisions in Hind Succession Act regarding the interstate succession of transgenders is a ground for dismissing the civil suit as not maintainable. Your Lordship, the counsel seeks permission to move on to the arguments.
You can go ahead.
Much obliged, Your Lordship. Your Lordship, by virtue of Section 2 of the Hind Succession Act 1956, the Act applies to any person who is Hind by religion in any of its form or developments. Hence, the Act does not disqualify a transgender person from the ambit of the Act. Your Lordship, Article 14 of the Constitution of India provides equality before law and promulgate that the state shall not deny to any person equality before law or equal protection of law within the territory of Indus. Your Lordship, discrimination against transgenders by ignoring them from the ambit of the Act, which governs the interstate succession among Hinds, is a hostile discrimination and is derogatory to the principles laid down by the Constitution of Indus. Your Lordship, in Section 2 Clause K of the Transgender Persons Protection of Rights Act 2019, a transgender person is defined as a person whose gender does not match with the gender assigned to that person at birth. And it includes trans man or trans women, whether or not such person has undergone the sex reassignment surgery or hormone therapy or laser therapy or such other therapy. Person with intersex variations, gender queer, and persons with such socio-cultural identities as Skinner, Hijra, Arwani, and Yogta. Your Lordship, this honorable court has held in Nalsa versus Union of India that gender identity is one of the most fundamental aspects of life, which refers to a person's intrinsic sense of being male, female, or transgender, or transsexual person. In certain persons, their innate perception of themselves is not in conformity with the sex assigned to them at birth and may include pre- and post-operative transsexual persons and also persons who do not choose to undergo or who do not have access to the operation, and also includes persons who cannot undergo successful operation. Your Lordship, the court clarified that gender identity did not refer to the biological characteristics, but rather referred to an innate perception of one's gender. Your Lordship, the court interpreted dignity under Article 21 of the Constitution to include diversity in self-expression, which allowed a person to lead a dignified life. It placed one's gender identity within the framework of fundamental right of dignity under Article 21. Your Lordship, under Article 15 and 16, discrimination on the grounds of sex is explicitly prohibited. The court held that sex here does not only refer to the biological...
Now, counsel, I have a doubt. You said that the court had clarified that gender identity did not refer to the biological characteristics.
Indeed, Your Lordship.
You quoted a decision, right? And now my question is, while defining a person under the Succession Act, how can we identify whether the person is a male, female, trans man, or trans woman?
Your Lordship, for transgenders, there is a certification procedure prescribed in the Transgender Persons Protection of Right Act, Your Lordship. So from that, we can clearly identify whether that person is a transgender or not. And the surgery or other aspects are not a factor regarding that.
What I'm asking you is a solution. How do we bring them, if we are accepting a proposition and we are bringing the transgenders to the fold of this act, how can we bring them?
Indeed, Your Lordship, the council is dealing with that in the later stage of the argument, Your Lordship, as to which section should be applied, Your Lordship.
Along the same lines, see, is there any statute in India presently which provides for, in the act itself, a definition of a transgender or a provision for a transgender. Now let's see the ultimate law. Does the Constitution itself, when it refers to he or she, does it have a specific reference to a transgender?
Your Lordship, the Constitution is actually gender neutral. The Constitution mainly uses the word person. Your Lordship, the person
Exactly.
is a very
So-
wider term.
So
and
the point is that any reference to a transgender has to be harmoniously interpreted to include that person, he or she, in each statute. That's the only way we can go about it. Otherwise, no statute in India can survive your definition, because no statute in India right now has a provision for a transgender. So the concept is harmonious construction.
Indeed, Your
So
Lordship.
if you go for harmonious construction in this act also, will you be satisfied?
Indeed, Your Lordship, a harmonious construction should be taken into consideration, Your Lordship. That's what the Council is trying to put forth, Your Lordship.
So if we adopt harmonious construction in the Succession Act, you're okay.
Your Lordship, what the Council is trying to put forth is that the non-mentioning of provisions or the non-mentioning of transgenders in the provisions of Hind Succession Act does not it does not make the suit for partition non-maintainable, Your Lordship. So
we are not at the question of partition. We are at the question as to whether transgenders have been included and provided for under the Succession Act. So my question is, if we harmoniously construct the interpretation of he or she to include transgenders also, then does your objection cease? And your objection as to the constitutionality of the act ceases?
Your Lordship, the objection as to the constitutionality does not end here, Your Lordship. It would end when the legislature passes an amendment which includes the transgenders in the Hind Succession Act.
So by that logic, all laws in India right now are unconstitutional according to you?
Your Lordship, it's not completely unconstitutional, but it does not.
Something as partially unconstitutional?
Your Lordship, there is a concept of severability that a certain portion.
What is the concept of severability? Tell me.
Your Lordship, when a portion
You are going deeper and deeper into trouble.
For the time being, let's differentiate between the civil rights and the constitutional rights. Right now, we are concerned only about the constitutionality of the law in question. Confined to that arguments.
Indeed, Your Lordship. Your Lordship, what the Council is trying to put forth is that it's a need of time to include transgenders in the ambit of the Act.
Now, would you be satisfied if we make a ruling that the law says that man includes woman? Wherever we use the word man includes woman, the word man, wherever it is used, it includes woman and transgender. If we give a general direction to that effect, will you be happy?
Indeed, Your Lordship. The Council would be.
Will that solve the issue as regards the Hind Succession Act? As far as transgenders are concerned?
Your Lordship, the term transgender, the issue is that the harmonious construction can bring into ambit the trans woman or a trans man. But Your Lordship, there are certain persons whose genitalia is not either male or female. So in such cases, the harmonious interpretation cannot bring about such persons, Your Lordship.
Okay, I agree with your proposition. We shall make a specific provision, or we shall call upon the legislature to include transgenders into the fold of this act. But will that solve the problems with regards to succession of transgenders? Succession rights? Do you believe that you will get equal succession rights as with regards to man and woman as per the Succession Act?
Indeed, Your Lordship. I think when the legislature frames those provisions, they must frame it in such a way that it brings about equality and equal protection before the law, Your Lordship. Your Lordship, may the Council move on to the argument?
Council, I have a small clarification because the thing is that, see, you filed this petition aftermath of a negative verdict from the court, right? So my question is, can you file the same question on the context that I asked to the prior speaker? Can you file a writ petition against an order of the civil court?
Your Lordship, even if Your Lordship, the council completely understands that.
The civil court dismissed your suit on the ground that there was no provision in the Hind Succession Act dealing with the succession of transgenders. And afterward, mother filed the writ petition under Article 32, and the ground was like the Hind law and non-mentioning of provisions regarding the interstate succession of the transgender is not a ground for dismissing the civil suit. So can you challenge a court order or a order of a civil court under Article 32 petition?
Your Lordship, the order, Your Lordship, even if an order
we are okay with, we are accepting all those challenges you raised under this petition regarding the non-mentioning of transgenders. Okay, that is justifiable. But my question is, one principal ground, that is, you portrayed it as like it is not a ground for dismissing the civil suit as not maintainable. So that is my question. That is my concern. There is my concern lies.
Indeed, Your Lordship, what the council is trying to propose is that the Supreme Court, the apex court, must give a direction to the lower courts that a harmonious construction should be made with regard to these aspects, so that the civil courts in future cases can utilize these guidelines and can harmoniously interpret the legislation, Your Lordship.
See, Council O1, where are you keep disappearing to? See, when the proceedings are on, I expect you to be on screen. Please don't disappear somewhere.
Indeed, Your Lordship, I beg your pardon.
Your Lordship, any council go on with that?
How much time left?
Much obliged, Your Lordship. Your Lordship, as I have said, under Article 15 and 16, discrimination on the ground of sex is explicitly prohibited. The court held that sex here not only refers to the biological attributes, but also includes gender, which is based on one's self-perception. Thus, this court held that discrimination on the ground of sex included discrimination on the basis of gender identity. Thus, the court held that transgender persons were entitled to fundamental rights under Article 14, 15, 16, 19 clause 1 clause A and 21 of the Constitution. Your Lordship, due to the absence of a suitable legislation protecting the rights of the members of the transgender community, they are facing discrimination in various areas, and hence the necessity to follow the international conventions to which India is a party and to give respect to the other non-binding international conventions and principles is a need. Your Lordship, Article 1 of the Universal Declaration of Human Rights 1948 states that all human beings, Your Lordship, I emphasize, all human beings are born free and equal in dignity and rights. Your Lordship, the Article 3 of Universal Declaration of Human Rights states that everyone has a right to life, liberty, and security of person. Article 6 of the International Covenant on Civil and Political Rights affirms that every human being has the inherent right to life, which right shall be protected by law, and no one shall be arbitrarily deprived of his life. Your Lordship, India has ratified the above mentioned covenants. Hence, those covenants can be used by the municipal courts as an aid to the interpretation of statutes by applying doctrine of harmonization. Your Lordship, in the instant case, the judiciary should not ignore the right of deceased Vairamani due to the absence of legislation. The court must try to incorporate. Your Lordship, the council seeks a few more minutes to.
You can conclude your arguments. You can conclude your arguments.
Much obliged, Lordship. Your Lordship, the court must try to incorporate an inclusive approach on interpreting the act. Your Lordship, Vairamani, though born male, is psychologically oriented as a transgender. On applying the definition of the term transgender, it can be understood that Vairamani's gender does not match with the one assigned during his birth, which is male. Therefore, Vairamani is a trans woman. That is, Vairamani is a woman who has been assigned male at birth. Therefore, under the current circumstance or in the current situation, Your Lordship, the court can utilize Section 15 of the Act, which can be applied to govern the interstate succession of Vairamani. Your Lordship, equality is a dynamic concept, and it cannot be restricted to any doctrinal limitations. The religious text and the Hindu mythology recognize three genders: male, female, and transgender, notwithstanding which the Indian law failed to provide protection to the transgender community. Therefore, the absence of legislative recognition should not be considered as a ground for non-enforcement of fundamental rights guaranteed by the Constitution of Indus. Your Lordship, if the bench is convinced with the arguments, may the council move on to the prayers.
Council, finally, the last question, what is your principal contention that this particular act, Succession Act, is totally failed to address or to identify a transgender? That's what your contention is, right?
Your Lordship, the legislature as such have failed to identify or bring into the ambit the transgenders, Your Lordship.
On that context, I would like to invite your attention towards paragraph number 31 of your written submission, in which you stated that by virtue of Section 2 of Hindu Succession Act, it applies to any person who is a Hindu by religion in any its form. Hence, Act does not disqualify a transgender person from the ambit of the Act.
Yes, Your Lordship. It is implied from the object of the Act. But when the legislature came into the provisions where the rules were framed, Your Lordship, the legislature has completely avoided transgender people, Your Lordship.
Section 2 is a what is Section 2?
Your Lordship, Section 2 is the applicability of the Act, Your Lordship.
So the applicability provision is extending or giving an umbrella concept, like it is applicable to any person, and you even admitted in your proposition, in your submission, that it is equally applicable to transgender. Then what is the scope of challenging the Act?
Your Lordship,
that?
Your Lordship, Your Lordship, the general rules regarding succession are binary. This is given binary. Your Lordship, even if the court tried to put on a harmonious interpretation, what we can include is trans women and trans men, as we have said in our 42nd point, Your Lordship. But Your Lordship, but the term transgender is it's like an umbrella term. So it not only involves trans men and trans women, but it also involves other genders, Your Lordship, other genders in the spectrum. So Your Lordship, it's a need of an hour that the legislation must recognize these persons also, as the Constitution of Indus provides equality for all persons, Your Lordship.
Okay.
Your Lordship, may the council move on to the prayer?
Yes, you may conclude your comments.
Much obliged, Your Lordship. Wherefore, in the light of the facts stated, arguments advanced, points raised, and authorities cited, it is most humbly and respectfully prayed that this Honorable Supreme Court may be pleased to adjudge and declare that the provisions of the Hindu Succession Act are in violation of constitutional provisions. The practice followed by Muslims based on Sharia, being a law under Article 30 in regard to inheritance of Muslim women, is violative of Article 14, 15, and 21 of the Constitution of India, whereas the non-mentioning of provisions in Hindu Succession Act regarding the interstate succession of transgender is not a ground for dismissing the civil suit as not maintainable, and may kindly pass any order this Honorable Court may deem fit. And for this act of kindness, the counsels for the petitioner shall in duty bound forever pray.
Could you just repeat what you said, the last prayer?
What is the last prayer? To declare that the suit is not maintainable. Is that within our power under Article 32?
Your Lordship, what the council is trying to propose is that the non-mentioning cannot be considered as a ground for dismissal, Your Lordship.
Exactly. So are you suggesting that in Article 32 we sit in appeal over a judgment of a lower court on a civil matter?
No, Your Lordship. The council expects the bench to provide an instruction to the lower court.
That was the crux of the question that I posted earlier.
Your Lordship, the council expects that the court give an instruction to the lower court to follow. Your Lordship, you're not audible.
Which writ allows us to give such an instruction to a court which pass a decree in a civil matter?
Your Lordship, Your Lordship, the
Yes, you can conclude, I think. I think maybe you can give me an answer and rebuttal.
Indeed, Your Lordship. Your Lordship, the counsel for the petitioner requests to speak, Your Lordship.
Okay, thank you, counsel. Thank you.
Good morning, Your Lordships. Am I audible and I'm visible?
Counsel, please wait.
Much obliged, Your Lordship.
Counsel, you can begin your arguments.
Much obliged, Your Lordship. Good morning. The Council seeks permission to individually address the panel as Your Lordships and collectively as the bench.
You may proceed. No issue.
Much obliged, Your Lordship. The Council will be representing the respondent in the case of Durga and Geo and others versus the Union of Indus, where Council 1 will be addressing issues number 1 and 2 and take a maximum time of 15 minutes, followed by my co-counsel who will address the issues 3 and 4 and take a maximum time of 15 minutes, while 5 minutes of our time shall be reserved for rebuttal. The Council for the respondent humbly reserves the right to challenge the jurisdiction of the court as under Article 32 of the Constitution. If the bench is well versed with the facts, the Council seeks permission to proceed with the arguments. Much obliged, Your Lordship. The Council, on behalf of the respondents with respect to issue 1, is dealing with whether the present writ petitions are maintainable. The Council, on behalf of the respondent, humbly submits to the Honorable Court that the current writ petitions are not maintainable on 2 counts. Firstly, that the fundamental rights of the petitioners have not been violated. Thus, there is no substantial question of law. And secondly, that the presumption of constitutionality extends to personal laws, and as personal laws fall outside of the ambit of Part 3 of the Constitution, the same cannot be questioned. With respect to the lack of substantial question of law, the Council, following the provisions...
Simple question. Do you agree that the Succession Act takes into consideration the rights of transgenders? Do you admit the fact that the Succession Act takes into consideration the rights of transgenders?
Much obliged, Your Lordship. The Succession Act does not provide provisions for transgenders, which is what my co-counsel will be covering more further in detail.
So isn't that an issue, a right of transgenders, their right to succession, a matter which has to be decided upon? Isn't that a substantial question of law?
Much obliged, Your Lordship. The objective, with respect to Article 14, the objective of the Act was never intended to make a law with respect to transgenders. Since this is something that has come up now, the legislature should be working on, and since substantive equality is something that is extended to transgenders, that is something that the legislature should focus on working now, but not make them fall within the ambit of the Hindu Succession Act. That is what we're contending.
Counsel, you are responding to the arguments raised by the petitioners, right? Yeah, the petitioners challenge the religious instructions. So you are raising the defense of presumption of constitutionality. So does that the principle applies over religious instruction, presumption of constitutionality?
Much obliged, Your Lordship. With the challenge with regards to presumption of constitutionality, we're challenging personal laws. While we understand that personal laws do encompass certain religious instructions, these religious instructions need to be tested on the parameter of essential religious practices. And if this essential religious practice is not something that is it would change the 1 minute, Your Lordship, is not something that is not where the absence of such a practice does not change the essence or fundamentally alter the religion, we can bring it to questioning.
Yeah, the question here is not at all circumventing around the notion of essential religious practice. We are dealing right now the matter of succession, and the matter of succession is way distant from the essential religious practice. So my question was clear.
Much obliged, Your Lordship. With respect to that,
my brother judge also do have the same concern that we would like to hear from you. What is your idea about essential religious practice?
Much obliged, Your Lordship. Before I move on to essential religious practice, I would like to bring light to the judgment of Ilyas versus.
No. First of all, yeah, let's we shall move on to the judgments. But before that, we just want to understand whether you have a concrete idea on what essential religious practice is all about. So we would like to hear from you. What is your notion about essential religious practice?
Much obliged, Your Lordship. Essential religious practices, the council believes is the practices that are. The council is not entirely clear on essential religious practices, but with respect.
When you throw out terms like this, like essential religious practice and constitutionality and words like that, they must have some meaning in your argument. So when you say, or
Much
when you
obliged.
defend your case on the ground that it is not an essential religious practice, you should know what an essential religious practice is.
Much obliged, Your Lordship.
Or at least whether this court or any other court has defined that, and whether that forms a part of your memorial.
Much obliged, Your Lordship. It does not
Now,
form.
now we are back to square one. So kindly answer my question. Can this religious instructions can be challenged on the ground of can be defended on the ground of presumption of constitutionality? Because when I perused your submission, that is one of the key legal argument on which you are relying upon.
Much obliged,
So
Your Lordship.
can we tested the doctrine of presumption of constitutionality on this religious instructions?
Much obliged, Your Lordships. What we even with our arguments when we've discussed presumption of constitutionality in our memorial submission, we have dealt with with covering the ambit of personal laws. If we were to account that religious instruction is part of personal laws, Shariat application, the Muslim Shariat Application Act is a personal law. So therefore, we believe when we're taking Section 2 of the Act, which deals with the property succession of women, with the property succession, interstate property succession, when we're dealing with that particular section, that does come within the ambit of personal laws, and that does come within the ambit of presumption of constitutionality. Moreover, succession for transgenders was covered in the case of Ilyas, where the court had stated that the personal laws outweighed the customs, where the custom was such that the property must devolve upon the transgender disciple, whereas the property devolved upon the religion which was being practiced and not upon the disciple. It was based on the Muslim law. So succession is a matter which has been dealt with regards to transgenders already by courts in earlier cases, as established with the Ilyas case.
So your argument is, where it is against custom versus personal law as codified by the statute, personal law should survive, right? Is that what you're saying? Have you understood my question? No, I'm asking you. Tell me, did you understand my question?
Much obliged. Could you please repeat the question?
Yeah, so I'm asking you, see, is it your argument that when the contest is between custom and personal law as created by the statute, the personal law as created by statute should prevail? Is that the crux of your argument?
Much obliged, Your Lordship. That was with regards to that particular case. That is for the court to decide whether they would outweigh the customs or the personal laws. Essentially, Article 13 provides for both. Article 13 allows for customs to come within its ambit. Article 13 in our present case, we are, while on grounds of presumption of constitutionality, we are contending that the certain personal laws do not come within the ambit of Article 13, and therefore fundamental right.
When you say certain personal law, what does that mean? What differentiate between personal laws that come within the ambit and those which do not come within the ambit?
Much obliged, Your Lordship. We're not content. We content personal. There are certain case laws which have laid down that personal laws do not come within the ambit of Article 13. But Article 13 explicitly allows for customs. So it is up to this court to decide whether they will acknowledge the customs or take into consideration the personal laws. If I may,
I didn't understand the answer. We didn't.
No, I'm also totally confused.
No, we have not understood.
Five-way rules. Just simply answer briefly, concisely, to the point.
Much obliged, Your Lordship. The point with regards to personal laws, I believe I've misconstrued. I've not gone as per my arguments. I'm sorry with regards to that. I will elaborate upon it later. But with respect to customs, customs are explicitly laid down in Article 13, and therefore they were considered in that particular code. Even with regards to personal laws, if this court were to consider it under the ambit of Article 13 and were to question it on the basis of fundamental rights, we have arguments to provide that there have been no fundamental right violations. If we were allowed to proceed with the same, we'll elaborate on it.
So the crux of what you're saying is that even assuming that these personal laws come within the ambit of the Constitution of India, there is no violation of Article 14, and that's what it's okay.
Much obliged, Your Lordship. If I may proceed with my arguments. Much obliged. According to Chunilal Mehta versus Century Spinning Limited, a substantial question of law would primarily arise only if the fundamental rights of the parties involved are directly or indirectly affected. In the present case, as the fundamental rights of the petitioners are not affected in any manner, nor have the rights of the citizens of Indus been violated by any action of the government, there is no substantial question of law, and thereby the present writ petitions are maintainable. It is humbly submitted by, as per the case of Maharishi Avdesh versus Union of India, Indus, the apex court has ruled that personal laws were a subject matter of state policy and the judiciary has no role with respect to the same. The court in this case held that a prayer seeking declaration of provisions of a personal law being arbitrary and violative of fundamental rights, along with a prayer seeking directions from the court to the state to not enact a particular legislation to protect the dignity and right of women, were matters of the legislature which cannot be legislated by the present court, leading to dismissal of that writ petition. Furthermore, the court in the case of Pannalal Bansilal Pitti versus State of Andhra Pradesh rejected testing of personal laws on the basis of Part 3 of the Constitution. They reasoned it by stating that while there is a desire under the directive principles of state policy to form uniform personal laws, Indus is a secular nation with faith and beliefs in their respective religions. The court stated that as a result, it would be inefficient and erroneous to believe that all laws must be made evenly applicable to all persons at the same time. The most serious wrongdoing or defect can be addressed through the legal system in phases. The apex court in the case of M.L. Kamra versus New Indus Assurance has stated that while there exists a presumption of constitutionality with statutory provisions, the same can be interpreted by this court when the provisions are prima facie unconstitutional. In addition to this, the apex court also mentioned that if any law is construed as constitutional in one interpretation and unconstitutional in another, the courts have to favor the constitutional interpretation. Even if the question of constitutionality of personal laws was to be entertained by this court, it can be found that the courts are obligated to favor the constitutionality interpretation over the unconstitutionality interpretation. Therefore, the writ petitions would be unmaintainable as there exists a presumption of constitutionality of a statute.
Now, counsel, I think the crux of the decisions that you have placed before us is that if there are two interpretations, earlier interpretations regarding the constitutionality and non-constitutionality of a particular provision, then we have to lean towards the constitutionality, correct?
Much of it, yes.
So in this particular case, please link that to the facts of this case. Where is this two sides in earlier decisions that your principle can be applied to?
Much obliged, Your Lordship. This is with regards, I was covering maintainability. My issue 2 deals with each particular case, and issue 3 and 4 also deals with each petition, which my co-counsel will be covering. So if I can elaborate as to how it would apply to each case. If I could proceed with my issue 2. Much obliged, Your Lordship. It is humbly submitted by the Council before this Honorable Court that the impugned provisions of the Hind Succession Act are constitutionally valid on 2 counts. Firstly, as there exists a presumption of constitutionality, and secondly, as there is no violation of right of equality and right against discrimination. Moving on, Article 14 of the Constitution discusses equality before law or equal protection of laws within the territory of Indus. If we look into the Supreme Court in the case of Om Prakash versus Radha Charan has applied Section 15 with has applied Section 15 and held it to be constitutional. The same was followed in the case of Saroja Chandrasekhar versus the Union of India. The constitutionality of Section 8 has not been brought to question for Section 8, which deals with interstate succession for Hindu men, has not been brought to question before any court until now.
Now, these decisions that you refer to, where in any of those decisions the question of constitutionality an issue to be considered?
Much obliged, Your Lordship. In the case of Om Prakash versus Radhacharan, there was no question of constitutionality, but the court did rule in the court did follow Section 15, and furthermore, Saroja Chandrasekhar,
That
which
is
is a
because the court was not called on to address that question.
much obliged, Your Lordship. But furthermore, in Saroja Chandrasekhar, where they did bring up constitutionality, the court did not rule on the same. And we find that there are certain petitions which were presented with respect to Muslim law, which also regarded constitutionality, where the court said Article 226 does not encompass to be able to question constitutionality, which is probably why Saroja Chandrasekhar did not rule on the same. If we move into Section 15, Section 15, in a book written by Harshvardhan Zaveri, the aim of a Hindu marriage was to ensure self-restraint and love for the entire family, to ensure that the family is united and to prevent its breakdown. The classification under Section 15 should not be considered arbitrary or discriminatory because it was not done solely on the basis of sex. But the difference in this case is that it is done on familial ties as well. This was covered in the case of...
Council, what you're arguing before us is that the act concerned, the statute concerned, is not at all gender discriminatory. That's what you're arguing, right? So on a plain reading, so many provisions under this statute is specifically mentioning about men and women. They're totally silent. For example, Section 3 Clause E, like F, it talks about hair. And in that particular, the literature specifically mentioning classifying between men and women. And also interstate, and also 8 and 15. All this, there are concrete words which specifying on men and women only. So don't you think like it is gender discriminatory because the plain reading reveals that?
No, just joining to that question, how would you interpret or how would you bring in the transgenders within that definition, and how would you make the act applicable to them?
Much obliged, Your Lordship. As will be elaborated upon by my co-counsel in issue 4, transgenders do not come within the ambit of Hind Succession Act, and to achieve substantive equality, the legislature should work on making a new legislation. Furthermore, with regards to the gender discriminatory, that is what my arguments were elaborating upon. Section 15 in particular, which is what the petitioners are contending in this particular...
Let me get this straight. You admit that the present Hind Succession Act does not make any provisions to transgenders, and we require a new law.
Much obliged, Your Lordship. That is what...
Is that your contention?
That is the contention, Your Lordship.
So you believe in multiplicity of laws rather than a single comprehensive legislation?
Much obliged, Your Lordship. That is already the present scenario of the... There are multiple succession laws. This cannot be taken as the grounds that there should not be a new succession law made for transgenders. There's the Indian Succession Act. There is the Hindu succession law. There is succession laws for Muslims. So when there's succession laws governing for so many various religions, there should be one...
So this would mean that we would require a special succession act for Hindu transgenders, another act for Muslim transgenders, and other act for other religious transgenders believing in other religions.
Much obliged, Your Lordship. That is for the legislature to decide, Your Lordship. This is not...
And until those laws are made, what happens?
Much obliged, Your Lordship. The court can issue direction. This court can take it upon themselves to issue directions of any matter.
So we can declare this as unconstitutional.
Much
and
obliged. Much obliged, Your Lordship. The Hind Succession Act, the objective of the act was never intended to make succession laws for transgenders. So how declaring it unconstitutional would deprive a lot of Hindu men and women who follow this act, and therefore, and it does not. If we go into the provisions, it only the Hindu Succession Act does provide for transgenders who recognize as men and women, which has also been highlighted in the case of Arun Kumar versus where a transgender woman was considered as bride under the Hindu Marriage Act. So any transgender person who recognizes themselves as a man or a woman, or they do come within the provisions of the Hind Succession Act. In this particular scenario, since the transgender person Vairamani does not consider themselves to be part of the binary, they cannot be construed to be part of the Hindu Succession Act.
You can conclude your arguments.
Much obliged, Your Lordship. I would just like to complete 2 paragraphs, and if that is urgent. Much obliged, Your Lordship. The classification under Section 15 should not be considered arbitrary or discriminatory, as it is not done solely on the basis of sex. But the difference is it is done on the basis of family ties as well, which was covered in the case of Girdhar Gopal versus State, where they acknowledged that the word only in Article 15(1) of the Indus Constitution is vital, since the discrimination solely on the grounds of religion, race, caste, sex, place of birth is prohibited. But discrimination which is not merely on the grounds aforementioned, it would not be hit by the provisions of Article 15. The same was covered in State of Rajasthan versus Thakur Pratap, where they stated that there were no grounds to the contrary which were identified, and discrimination was only based on but discrimination was based on the reasons laid down in Article 15. But in this case, we are clearly stating that the discrimination is based on familial ties and not sex. It is based on marital ties. And the objective of marriage in Hindu law is to make sure the family is united. Therefore, Section 15 is constructed in such a way. The court in the case of Mamta Dinesh Vakil versus Bansi S. Vadva held that the mother being placed in a class above as per Section 8 is not reverse discrimination but positive discrimination. They stated that this situation is one of positive discrimination by affirmative action, since it is of general knowledge that the mother would not be able in her position to maintain herself following her son's demise. The court stated that in the ground reality of our society, a father generally has his own means of livelihood, which is not the same in the case of a mother. While the court did not rule on this issue since it was not pertinent to their suit, they did mention that if an amendment to this rule was to be brought about, it was to be brought about by the legislature and not the judiciary. The court in the case of Nikhil Mohan versus State of Maharashtra further went on to mention that the money spent to educate the child is the responsibility of the parents. So if the parent, in this case, if Mr. Hemant comes and contends on the grounds
Counsel,
that...
I believe you can conclude your arguments. You can conclude
Much
your
obliged,
arguments.
Your Lordship. The main crux is the petitioners have completely disregarded Mr. Hemant's petition, but by taking Mr. Hemant's petition into consideration, we hold that Section 18 is his petition is unmaintainable, and Section 8 of the Hindu Succession Act is constitutionally valid. Section 15 is also constitutionally valid. Therefore, this is what is humbly submitted by the counsel for the respondents, that the impugned provisions of the Hindu Succession Act are constitutionally valid, as there is no violation of rights, and therefore the counsel would like to call upon the co-counsel to present the remaining arguments.
Good morning. This is the co-counsel for the respondent, representing the respondent in the case of Durga NGO and others versus the Union of Indus. If the courtroom master may please confirm if I'm both clearly visible and audible.
You can proceed.
Much obliged, Your Lordship. The council seeks permission to proceed with issue 3 with regards to whether the provisions of the Muslim Personal Law Shariat Application Act, hereinafter referred to as the Muslim Personal Law, is arbitrary regarding the daughter's share in inheritance in an intestate succession.
You are not that clear.
Am I? Is the council clearer now?
Yeah,
Your
that is better. But you may not be able to do the entire arguments holding your hands like that. So I think you should make some other.
I shall definitely try, Your Lordship. Just a minute. Is the council clearer now?
Yes.
Thank you, Your Lordship. If I have the Honorable Bench's permission to proceed with the arguments regarding issue 3.
That's what we are here for. You don't have to seek permission every time.
Much obliged, Your Lordship. It is humbly submitted that the Muslim Personal Law with regards to inheritance of daughters in an intestate succession is constitutionally valid and not arbitrary on 3 major bases.
I expect a little clarity over one matter, which your sister counsel just presented before us.
Yes, Your
Your stand was that when my brother judge asked a question, one of the statement made by your sister counsel was, it is a duty of the legislature. As a responsible officer of this court representing the state, what is the rationale behind such a statement? Because you are the one representing the state. Legislature is part of yours. So as a responsible law officer from the part of the state, what is the rationale and what is the logic behind such a stand? Are you also taking the same stand, or
Your Lordship, I stand by my sister council's stance, and I will further elaborate on the same as to why we are taking such a stance, stating that it is the legislature's arena to deliberate on the same with regards to possible amendment or additional provisions for said act, and we have
You made the law, and the law concerned right now is the language of the law is visibly discriminating between gender, and we are posting a question that the law made by you is problematic. Then the argument that you're saying is that it is the duty of the legislature. Then who are you representing?
Your Lordship, first off, I would like to tackle your questions in two separate counts. Firstly, the present act with regards to both the Muslim Personal Law as well as the Hind Succession Act with regards to transgender people is not gender discriminatory, first off. Secondly, it is as elaborated in various cases such as Riju Prasad versus State of Assam. This very honorable.
Let's pause there. I'm not. You have the time to argue further, but this statement is problematic because you are the one representing the state. When we have a serious concern about the law made by the state, when we ask this question as a law officer representing as an officer of this court representing the state, you're taking the stand that that is the responsibility of the state. Then who should we ask for clarification and clarity?
Your Lordship, the Council would very much like to clarify that the judiciary is the preserver of the laws of the nation, and it is very well within the judiciary's authority.
Who are you representing? Who's your client? Who's your?
We're representing the Union of Indus, Your Lordship.
Who made the law?
The legislature, Your Lordship. But, well, essentially the legislature passed a statutory declaration of the personal laws of the religions.
Union of the legislature is part of
the parliament, Your Lordship. One of the.
This law is made by you, right?
Yes, Your Lordship. We've passed a statutory declaration for the same, Your Lordship. We haven't made the law per se.
Okay, counsel, you can continue. We will ask. We will ask if any clarity is needed. That time we will ask.
Much obliged, Your Lordship. The Council thanks you. So with regards to the Muslim personal law being constitutionally valid and not arbitrary, with regards to the daughter's inheritance in an interstate succession, the Muslim personal law is constitutionally valid on three major counts. Firstly, Ms. Fatima's concern is isolated only to this present case. Secondly, age-old customary laws which the communities have acquiesced through over the years cannot be altered without majority movement. And thirdly, as was stated by my sister council as well, it is the jurisdiction of the legislature to amend these laws. It was firmly.
Counsel, what is the logic in the Shariat law for fixing double the share for son and half the share for the female child? What is the logic behind that?
Yes, much obliged, Your Lordship. The primary logic for the same is that the primary concept of security for daughters in the form of property is through meher and not through inheritance of the ancestral property of their natal home. That is the primary.
Who provides for meher?
The husband's family, Your Lordship.
So then how does your argument work?
Much obliged, Your Lordship, but the fact is that it is the precepts that was laid out in the Holy Quran, which is the primary legal source for the Muslim community, and the Muslim community has been following the same through the years without any without any contrary reasons raised with regards to this provision. Then, therefore, as representative of the
a Muslim woman, lady, she finds that she will get only the half the share of what her brothers get. She decides to undergo a sex change operation and decides to become a man. Then will that person get the equal share as that of her brothers?
Your Lordship, The recent case of Ajay Matlupal, which I believe has the very same situation. It was held that the court will give the property to said trans man because he had undergone such change, but the court firmly regretted the fact that such a situation had to be carried out, and the court firmly warned against such a situation as well.
So shall we take another similar situation where a person has 3 children, a female, a male, and a transgender? Then as per your logic, how will the property be divided?
Your Lordship, with regards to the Muslim personal law in an intestate succession, the son will get uh, half of the property. The daughters will get only half of what the sons receive, and the transgenders, we will elaborate on the same. But the primary argument that the council is putting forth is that though the current succession acts do, especially with regards to transgender persons, do not cover the succession of transgenders. However, the reason for the same is because largely succession is governed by binary construct of genders, and as representative of the government, the council is stating that the legislature is in
So
a
until
formulation.
then, what about the constitutional rights of the transgender child?
Your Lordship, this honorable court may pass directions as to the same, but cannot invalidate the succession acts just based on the concept that they do not include transgenders, because there is a binary presentation.
That is the basic concept of constitutionality, that all children should be treated equally, or at least on the basis of some rationale. By your argument, there is no rationale in excluding the transgender. You are just saying for the transgender to wait for the state in its wisdom at some point of time to bring in a succession law, and until then keep quiet and not have an access to the parents' property. And what about testamentary succession in Muslim persons? What is the position on that?
Your Lordship, with regards to daughters, if there is a testamentary succession, the daughters can contend if they feel that the property that they received is in very description to their brother's property. The daughters can contend. However, in an interstate succession, that is not the case.
No, in a testamentary succession, can a Muslim male or female will away the entirety of their property to whoever they like?
Yes, Your Lordship, I believe so.
That is your understanding of the law.
I believe so. Yes, Your Lordship.
Okay.
Moving on with my further arguments, Honorable Bench. As stated as one of the primary counts, the Holy Quran is one of the irrefutable primary sources for the personal laws of the Muslim community, and the rights of women firmly encompass certain securities that is as per the Holy Quran only. And this interpretation was made by the prominent case of Muhammad Naseem Butt versus Bilqis Akhtar, wherein the court held that dower through meher is the primary, if not the only property to be received by the daughters. The right to equal share in the interstate father's property is not one of the classes, and is therefore not one of the primary rights of the Muslim person.
Again, the problem there. See, when you say that meher is the primary source of income for the daughter, it is not the father who is providing the meher. Then how can you say that is a proportionate share of the father's or mother's property to be obtained by a female? Because meher is being obtained from the husband's side. That is like saying that if I am having employment and I am receiving salary, then I am not entitled to a proportional share in the assets of my father if one of my other siblings does not have a job.
When it is getting quantified, there will be disparity.
Much obliged, Your Lordship, but irrespective, we get that there would be a disparity. However, this is the personal law that has been upheld by generations of Muslim communities without a single contrary voice raised until this present case, and that too it is isolated.
Customary law also recognized sati for hundreds of years until it was found to be barbaric. So is dowry. So are you saying that the very fact that, or the only fact that it has been followed for hundreds of years is a justification to keep alive a arbitrary provision?
Not at all, Your Lordship. We're not saying it just because it is an age-old custom that it should be validated. We're saying that unless there is a majority movement to be called for said invalidation, then
Is there a provision for conducting a referendum to decide what the majority wants? How do you decide what the majority of a community wants? How are we supposed to know? How is the parliament going to find out? Is
So
there a
do you
mechanism
mean
in
to say that
place?
if 100 petitions come before this court, we can allow those petitions? A single petition cannot be allowed.
no, Your Lordship, that is not the rationale. The fact that in the present case and as far in the legal history, there has been only this isolated case of Muslim daughter seeking for equality in inheritance is contrary. And furthermore, it was laid down by various MPs over the years, such as Shri Ram Nivas Mirza, who is the then State Home Affairs Minister, and Shri Salman Qureshi, the Minister of Law and Justice, in both the Rajya Sabha and the Lok Sabha proceedings, that the legislature cannot delve into such an aspect without majority call for such change from the Muslim community. And it would be contrary on the
When you speak of a word majority, that's a vague concept. And how can we rest on the constitutionality of a provision on the basis of the concept of majority when we don't know what the majority says or knows? How do you tell me, how do we decide what the majority wants?
Your Lordship, uh, as representatives of the government, the legislature is in works of doing a survey to understand whether um, uh, the Muslim women daughters are satisfied with their rights, and the legislature is taking cognizance of the same. And further, in the case of Pannalal Bansilal Pitti, it is said that the legislature should have the freedom to bring about gradual progressive changes, and the progress may start.
Do you think the majority of the members of parliament will constitute the majority of the interest of a community?
Not at all, Your Lordship. We definitely
No.
don't agree with that.
Then what is the concept or logic in passing laws on the basis of the majority in parliament?
No, Your Lordship, it wasn't the majority in the parliament. It is the majority of the Muslim communities
No.
that had.
See, no. You do not understand my question. My question is, how are laws passed in parliament? Are they passed by a majority of the members voting?
Yes, Your Lordship, that we agree.
So if the majority of the persons in the parliament are in favor of a change in personal law, will that reflect the majority concept that you are speaking of?
The members of the parliament they represent the interests
Exactly.
of the various communities of Indus, Your Lordship, and
Yeah,
therefore.
so I'm trying to help you is what I'm doing.
Your Lordship, we're representatives of the government and we stand by our legislature.
Okay, continue.
Much obliged, Your Lordship. That is the primary argument for the constitutional validity of the Muslim personal law. The council will now move on to the impugned Hind Succession Act regarding the fact that it does not include transgenders. However, the same contention on the petitioners is Your Lordships, if I may request for more time to complete with my fourth issue.
Please try to conclude in 2 minutes, otherwise it will eat into your rebuttal time.
Much obliged, Your Lordship. So it is submitted that the Hind Succession Act is not arbitrary or void simply because it does not make provisions for the people of the transgender community who are considered fluid between the genders on three major counts. Firstly, the Hind Succession Act was never intended for people beyond the binary construct of gender. Secondly, the third gender community could never be included in the Hind Succession Act with respect to the concept of substantive equality. And thirdly, interference with personal laws, which have historic reasoning behind the provisions for the binary genders, is not to be considered at this point. Judicially, it has been held over the years that the Hind Succession Act only encompasses the binary gender spectrum. This was held in various cases, such as I, Jacqueline, Mary versus
Counsel, please explain to us what is this notion of substantive equality that you.
Yes, Your Lordship. So substantive equality is essentially the concept wherein backward communities should be given the benefit up to which equality can be provided to them. So they must not be clubbed into people with people who are supposedly in alike communities, but not so.
See,
They should be
Council, when it comes to succession is concerned, succession is not at all, not only lies in a piece of paper or a will or a deed. There are so many procedures which are involved with, uh, right from the grassroots level. So if a principal statute is totally silent about one gender, so can you imagine what are the difficulties that it creates during the procedure is concerned? So this statute is very much visible for the fact that it is totally silent about this gender. So how can you say that this statute is credible and concrete when it comes to third genders are concerned while protecting the rights of third genders?
Your Lordship, the primary contention of the respondents on this part is that the Hindu Succession Act was never meant for people of the third gender. The Hindu Succession Act provides for people, male and female, both medically identified at birth and self-identified.
This court in multiple occasions accepted, recognized these third gender, as we call them. It's not a right term, but these transgenders are also people. They are also gender. So this, it is unfortunate to hear from a representative of the government in this court that this act is created only for the purpose of men and women, not for the purpose of transgenders. It's really unfortunate.
Your Lordship, the Council is just merely stating what the honorable courts have stated before the years. The case of Jacqueline Mary versus Superintendent of Police Karur has stated that the Hindu Succession Act is largely specific and gendered in binary gender nature. And the Council also would beg to clarify that the Hindu Succession Act caters to biological male and female people as well as self-identified male and female people. However,
so you may conclude with your arguments, please.
Yes, Your Lordship. So the primary arguments of the Council with regards to the Hindu Succession Act being constitutionally valid is that the objective of the Act was never to cater to people for the third gender, and the legislature is in the works of creating an adequate document for said Tritiya Prakriti, third gender community, and therefore even the prominent case of Nalsa refrained from delving into the personal laws for the Tritiya Prakriti community. And that is one of the primary contentions that the Council is putting forth, to state that the Hindu Succession Act is constitutionally valid and not arbitrary simply because it does not include such Tritiya Prakriti. With that, the Council for the respondent rests their case.
Thank you.
Thank you, Your Lordship.
Petitioner side, your rebuttal time is limited to 2 minutes.
Yes, Your Lordship. The Council seeks permission to rebut. Much obliged, Your Lordships. As stated by the Learned Council constantly kept saying that the fundamental rights have not been violated while considering Section 15 of the Hindu Succession Act 1956. However, no rational nexus has been established in the same case. And furthermore, with regard to receiving meher, it is submitted that it has got nothing to do with the rules of succession. In fact, if I can bring the Learned Council's notice to a survey that was made on how Indians view gender roles in family and society, as per the responsibility of making decisions, almost 73% of people believe that both men and women make that decision. And when it comes to responsibility of earning income for a family, almost 54% of the people believe that both men and women have such a responsibility. So when it comes to earning income from the family, as well as taking financial decisions, both men and women have an equal role to play in the same, and therefore getting a lesser share is not justified. If my co-counsel would like to add anything to it.
Your Lordship, the Council number 2 seeks permission to rebut.
I believe
Yes.
rebuttal can be only by one person. You can discuss with the co-counsel and
And you have also to answer my question that you had passed over for rebuttal as to how you can seek a relief regarding setting aside a suit in a writ petition.
Indeed, Your Lordship.
Your Lordship, another thing that the Council would like to mention is how the Learned Council constantly kept using the word third gender. However, this is wrong and offensive.
I think in the unique scenario that we are in here, I think your co-counsel can also be allowed to answer in rebuttal because you are in two different places, I believe.
Indeed, Your Lordship. Much obliged.
Your Lordship, the terms used by the learned counsel representing the respondents as third gender is highly offensive. And also, Your Lordship, as a representative of the state, they themselves have said that the Hind following transgenders are not included in the ambit of the Hindu Succession Act. Your Lordship, if the point of view of the state itself is this, the transgender community is being sidelined and is being made vulnerable again. Your Lordship. So such aspects or such contentions by the learned counsel for the respondents should be taken aback, Your Lordship.
And no answer to my question.
Your Lordship, what the council was trying to put forth is that if the apex court could give a guideline or direct the lower court to
Exactly my point. Under what provision of law? That is all I am asking. We are more than happy to do that for you,
Even if it is
provided
NSLP,
you have we have the power.
Even if it is an SLP, we cannot do anything.
Your Lordship, the council believes
You are the one who prayed likewise. You are the one who seeked for such a prayer, such a relief. Now you are not that much.
Your Lordship, the council believes the court can issue a certiorari, Your Lordship.
You are getting into more. Thank you, counsel. Thank you so much.
Pardon, Your Lordship, for that aspect, Your Lordship.
I think 3 minutes to B.
Much obliged, Your Lordship. Your Lordship, before we proceed with the argument, with our sir rebuttals, could we know whether even we can do it? Like even even my co-counsel can speak with regards to sir rebuttals.
Both of you can speak.
Much obliged, Your Lordship. Starting with my sir rebuttals, Your Lordship, they mentioned that we did not give a clear distinction or rational nexus with respect to how Section 15 is not constitutionally invalid. We've already mentioned that Section 15 discriminates on the basis of marital ties because the aim of Hindu marriage is that to keep the family united and to keep the family one, as we've cited a book as well as a journal article for the same. And the discrimination in the present case is not only on the basis of sex, but on the basis of marital ties.
Counsel, just one doubt. You referred to an article by one Mr. Rajiv, right? When you were discussing about family ties in your argument, you have mentioned one article, have you not?
Much obliged, Your Lordship. The article mentioned it was not by Mr. Rajiv, and it was not mentioned in the oral pleadings. It was on our memorial.
Okay, no, that's exactly the point. I wanted to know what was the qualification of the person writing the article that you chose to refer to that before the apex court.
Much obliged, Your Lordship. If I may complete my served rebuttals and then I can jump.
Okay.
Much obliged, Your Lordship. Moreover, Your Lordship, this is what we were trying to establish, that this is the rational nexus. This was a reasonable classification to keep the family united, to keep the marriage united. Moreover, my co-counsel would continue with their arguments, but the reason for citing such a source was that Hindu, they are. We used that journal article since it covered with respects to marriage and mental health, and it was published in an Indian. It was published in a reputed journal, and it was.
The reason I asked was, what are you aware of the qualification of the author to write such an article and to establish or bring before this court as a authoritative subject?
Much obliged, Your Lordship. The counsel seeks pardon. We don't. The qualification of the author. My co-counsel will proceed with.
Thank you. Your Lordship, with regards to the contention posted by the petitioners, in the referral of the counsel to community of people who are fluid between the genders as third genders. Your Lordship, the council only referred to the same in terms of differentiation, and further, the council would also like to cite the very Mahabharata, one of the primary Indian epics. The use of the word Tritiya Prakriti, which essentially refers to people of people who do not fall into either of the two genders, but who consider themselves to be fluid between the two genders, and that is, for example, the prominent hero of Shikandi. And that is what the council meant for the sake of argument for clarity. And further, moving on to the concept of meher, Your Lordship, we're representatives of the government, and we aim to uphold all the views of the communities that Indus has in its ambit, and we want to uphold every one of their religious beliefs. And it is, as per the Holy Quran, the primary source for Muslim law, as per the Hanafi school, that it was stated that right to meher is one of the primary, and if not the only right to property to be secured by women, and that is the argument posted by the councils with regards to the same. We would definitely not want to. We would definitely want to let any community's voice not be heard, and we represent every community's voice with regards to the interpretation. And
Council,
further, that's Your Lordship.
yeah, okay.
And moving on to Your Lordship, if I may bring up the point of the petitioners in referring to international treaties and stating that since India has ratified the same, we have to follow such a treaty. Your Lordship, it has been held in various cases such as Jolly George Verghese versus Bank of Cochin, as well as State of West Bengal versus Kesoram Industries. There is always a national law that should be given precedence over such international conventions. And further, and also in certain cases, India has only signed such international treaties, but not necessarily ratified them as to all the sections, and therefore the same should be taken into account as well.
See, what I was going to say was that assuming that you are going on to the next round, as far as P2 is concerned, there are some problems with the clarity of your arguments. All of us feel that you are not coming through properly, so we are not able to understand you perfectly. So please do something about that, assuming you are going into the next round.
Yes, Your Lordship, we will definitely work on that.
Much obliged, Your Lordship. With time permitting, can we mention one argument?
No, your time is up. Your time is up. Thank you and best of luck for both teams.
Thank you, Your Lordship.
Thank you, Your Lordship. It was a pleasure pleading before this bench. Thank you so much.
Much obliged, Your Lordships.
This is a very tough round. Both of you performed very well. Team O has got a team total of 444. Team P mark is 448. Team P has entered the finals. It was a very tough round. I can only say that the memorials made the difference. Okay, all the best.
Thank you very much, Honorable Judges.
Much
It was a
obliged,
pleasure.
bro.
And thank
Thank
you,
you.
Team O as well. for
Congrats,
playing.
P.
Yeah,
Congratulations and good luck for the finals, team.
Thank you very much. It was a pleasure.